Hello, everybody.
We're here today on a status for Mr. Creamer. Is that correct?
Yes, sir.
I thought I'd ask of Life Management about an opinion whether Mr. Creamer, because he's under a incompetency.
Yes, sir. And we did get a letter from Life Management with recommendations, but I've learned today that Ms. Diabra received a more updated one with a different opinion. Want to speak to that?
Yes, Your Honor. A progress report was filed on the 9th, in which Life Management, the counselor and case manager, met with Mr. Creamer and discussed the potential conditional release agreement, but Mr. Creamer was not accepting of it, and that's the latest update we have from Life Management.
I think what I asked Life Management to do is give me an opinion whether whether the Life Management jail plan is the least restrictive, or I need an opinion whether Mr. Creamer needs to be sent to the Florida State Hospital.
Yes, sir. You understand what the judge is saying? Yes. Okay. So, Judge, this is what I've heard from Mr. Creamer. I believe that the issue is the indefinite nature of the contract for Mr. Creamer. I think what he was looking for is a time frame, and I think that what he thought is that basically this could last in perpetuity. So that, I think, is his issue.
Yes, sir. And there's nothing that can be moved on this case until I find you competent. There's absolutely, this case comes to a grinding halt. And if you refuse to cooperate with Life Management, I know that you're not rude to them, but if you refuse to cooperate with Life Management, we'll stay right here until I can find you competent. Because if I do anything else, it will come right back to me. And what I want to know from Life Management is if they can't restore you in the jail, I'll need to send you to the Florida State Hospital in Chattahoochee.
So, Garrison, what's happening here is they're saying, listen, if you don't take the medication, then the next step is Chattahoochee. You understand? Yes. I mean, that's the judge. He's in charge of this proceeding.
And I'm in charge of it, but I am bound by the law. So there's things I can do, but I can't find you competent until I have someone come in and give me testimony that you are competent. And since there's been a finding that you're incompetent, that's where I'm at.
So he has to abide by the law. There's no one that's going to find you competent until there's some medication. Okay.
The only thing I would say is that the only prescription I feel I need filled is just a big heaping dose of the Constitution.
Okay, well, that concludes this hearing. What I want Life Management to do is give me an opinion whether the Life Management is the least restrictive measures available. If they're not, I'll need a report to that, and we'll have a hearing whether the Florida State Hospital is the least restrictive.
Thank you, Judge.
I'd like that done by January 24th.
Thank you, sir.
That's what we'll set for a hearing.
Okay.
Judge, we can handle Lamar Anderson.
Mr. Anderson?
Judge, we're just here for a bond motion on Mr. Anderson. I believe you heard some from Ms. Peskin on Wednesday. I did want to bring you the exhibits that are the main issue in this case. I think they shed some light on the issue.
The problem with all that is that what's the state's opinion on it? What's their position? Isn't this your case, Ms. McAfee?
Yes, Your Honor. My position on it, as it was I didn't object to a monetary bond, but I was leaving it to the court's discretion and what they want.
Well, if I'm going to consider evidence, I'm going to consider evidence in an evidentiary hearing and not in a bond hearing. I mean, this is a violation of probation. I mean, a violation of probation. I know he has I believe it's a driving under the influence.
Yes, sir.
That I think Ms. Peskin's position was that it was not a good video, but I mean, that's not the end all be all of driving under the influence.
Yes, sir. Understand.
So, I mean, that's where I'm at this time is if you want to set up for an evidentiary hearing, I'll do that January 22nd, right?
Yes, sir.
We can do that and take care of it all.
Yes, sir. Sounds good.
Okay. We'll do that at 9 o'clock. We'll set that for a 9 o'clock preliminary and 1:30 evidentiary.
And Judge, the last motion I have is in custody, but he is out now. Mr. Smith, come on up, Mr. Smith. And the gentleman approaching, Your Honor, is Joshua Adam Smith, 24-1209 CFMA. Your Honor, Mr. Smith had asked me to file a motion for a bond reduction. I do know that he has one witness that is in the audience. Do you wish me to have her testify? Okay, Your Honor, so it should be brief. Besides the one witness, my client's the only other witness. So, ma'am, if you would come forward if you'd like to testify. You'll be on this side so you don't get in trouble. Yeah. Raise your hand.
Promise by the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God. Yes.
Okay, go ahead and tell the court your name.
I'm Nicole Goldsberry.
And how do you know Mr. Smith?
I am married to him.
All right. And how long have you been married?
Not very long.
Less than a year?
Yeah.
Okay, fair enough. As you know, Mr. Smith has a number of charges, some of them considered to be of serious nature, and a bond that the family is not able to afford. Is that correct?
Yes. that is-
All right. If the court were to reduce the bond to one that the family was able to afford, would you have a place for Mr. Smith to reside?
Yes.
And
I
where-
have a home.
Where is that residence located?
Panama City.
And would you be able to make sure that he is able to get to and from his various court hearings?
Yes.
Are you aware of any potential job employment he may have awaiting him if he were to bond out?
Both of his jobs agreed to take him back as soon as he's released.
And what type of jobs are those?
He has one with Mike Ferris Construction and Circle K also.
And that would allow him to still do work local here in the
Yeah,
Bay County area?
In Bay County. Mhm.
All right. As far as posting bond, is there a particular bondsman that you are aware of that has worked with Mr. Smith or is willing to post bond?
Billy Clark.
Billy Clark is the
Yeah.
one that's interested. All right. With respect to Mr. Smith, do you have any concerns about failures to appear if he were to be released with you being in charge of getting him to and from court?
No.
All right. I don't believe I have any other questions. The state is certainly allowed to ask as well.
Ms. McAfee, any questions?
No, Your Honor.
All right, ma'am, you can have a seat.
Thank you, Ms. Goldberg.
Your Honor.
Oh, you need to swear him
Yeah,
in.
the clerk will put you under oath.
Promise for the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Okay, Mr. Smith, just to kind of start off, you heard the questioning I just asked of your wife. It's my understanding that the current bond is more than your family is able to afford. Is that correct?
Yes.
And if the bond were reduced to an amount your family could afford, is it true that you would be staying in Bay County with your wife?
Yes, sir.
And is it also true that you would be able to get to and from all of your court dates?
Yes, sir.
Do you have a vehicle yourself, or would you be relying on your
Well,
wife?
I have to rely on that vehicle. I do have my driver's license. I got my driver's license back before I was ever arrested.
Okay.
I lost my vehicle since I've been in here.
All right. As far as employment, you heard your wife mention a couple of different options. To your knowledge, is that accurate? You do have jobs waiting for you?
Yes, sir. Both my jobs are happy when you take me back. I work for Circle K out on Panama City Beach, and then a construction company, which is inside here.
And you also heard her mention Billy Clark bonds, but if you were to post bond, you feel confident you would be able to comply with whatever terms and conditions, not only by the court, but by your bail bondsman.
Yes, sir.
Is there anything else you wish to have the court know as far as why you feel you need to post bond, perhaps to take care of family members financially,
Yes.
emotionally, or that sort of thing?
That too. Plus my daughter's going to UCF. She leaves in January, so I probably won't see her for a while until this is resolved.
She leaves
And
where?
She's going to University of Central Florida.
Oh, okay.
And then my son is supposed to be going to military training. So I'm trying to spend some type of time with him before this case is resolved. I know it's probably going to be a while.
Have you had a failure to appear in your past?
No, sir, I haven't.
Your Honor, I don't believe I have any other questions. Obviously, the state.
Ms. McAfee, any questions?
No question, Your Honor.
Mr. Sleen, any other witnesses?
No, Your Honor, I believe that's all we have.
Does the state have any witnesses?
No, Your
All right, I'll allow the state to make the argument, and Mr. Sleen, I'll allow you and your client to respond.
Yes, Your Honor.
Your Honor, the bond in this case is a reasonable act of defense. The charges, as you are aware, charges count one carry a minimum mandatory of 25 years if convicted as charged for this dangerous substance. Looking at the defendant's history, he just had a prior trafficking in amphetamine back in 2018, as well as prior pleas to elude and other drug charges. This is not a case that warrants a reduction in bond.
Mr. Sleen?
Yes, Your Honor. Judge, as you heard from the testimony, my client is married, has a place to reside here in Bay County in Panama City. Sounds as though he had two jobs before being arrested, and both jobs are interested in taking him back. He does have a driver's license and his wife has a vehicle that he could drive or she could make sure he comes here to court. The record seems to indicate that there are 0 failures to appear previously. I'm sorry.
Always came.
And he's always appeared in court as requested. He has children, one entering school, one entering the military, so he has ties to the community and does not appear to be a flight risk. It appears as though he's resided here in the Panhandle pretty many whole life, to my knowledge, as he, I should have asked you that, but he has resided here his whole life. And so for those reasons, Mr. Smith is asking the court to reduce the bond. He certainly respects the nature of the charges in his prior history, but is simply asking for something that his family can work with a bondsman.
Well, based on his prior, I've considered his contacts with the community, and also had to consider his prior record and the charges that he's being faced. So what I'm going to do is on the trafficking in fentanyl, which was filed in the information, I'm going to reduce that bond from $500,000 to $250,000. I don't believe the sale of fentanyl, y'all, Ms. McAfee, correct me if I'm wrong, I don't believe the sale of fentanyl was charged.
I believe that is correct, although in charge.
So that 25,000 will come off. I'm gonna leave the trafficking in methamphetamine at 250,000. The sale of methamphetamine, I'll leave it at 25,000. I'll leave the use of a two-way communication at 5,000. I don't believe he was charged with the intent to deliver marijuana, which is 5,000. I'll reduce that. I'll release him on that, on his own recognizance, or just oral him, and on the drug, or he's just released. It's not an oral because it hadn't been filed. It's just released on that. That bond is taken away. On the possession of paraphernalia, it's $2,000. That's also, he's released on that prior to the state not filing that information on that. Okay?
Thank you so much, Your Honor. My client was asking me about whether we're permitted to allege that the facts in the affidavit don't match the charging decision. I just explained that's not something the court would normally be involved with in a bond reduction. That's more of a trial issue or a motion issue for suppression and things like that. But
All right.
we do greatly appreciate your kindness, Your Honor.
We need to set him for a pretrial. When do you want to set him?
Judge, we need to conduct depositions. There may be a motion to suppress coming at the client's request after those depositions. So I would defer to the state's calendar.
February 21st?
That's fine, Your Honor. We can always move you up if we need to, but I know-
All right, February 21st at 9 o'clock.
do you want me to investigate it? If I don't-
No, I'm sorry, February 20th at 9 o'clock for a pretrial, and then we'll wait for motions filed.
Thank you. Thank you.
All right, thank you, Mr. Smith. Glad to see you. Thank you. All right, Ms. McCarthy, I think that's the parent or the mother of the, and I can't remember the woman's name who we had examined. Yeah.
She's already been ordered to the hospital.
All right, you may want to, if you'll talk to them, okay? We'll go off the record. Ms. McCarthy, you want to speak with Ms. Henson's
Yes, sir, I'll do that.
mother? Yes, ma'am, but you might not want to hear what I have to say.
Well,
Let's go on the record, let's go on the record.
okay. Still my evidence got hit you 3 times and it did not serve.
Let me tell you what's going on.
Okay.
I'm assuming this is the gentleman who filed the charges on her.
No, that's my husband.
Okay, well, there was somebody here I thought that had a grand theft auto. Who was
No,
that?
that was Neil Hickam.
Okay,
He
let me
wanted
just,
the charges dropped.
doesn't matter. When you get law enforcement involved,
I understand that.
and there's nothing I can do. When she has a felony pending against her, I can't do anything with her until I find that she's competent.
But she's not competent.
Only place I can send her is the Florida State
You
Hospital.
can't send her to Life Management.
No, ma'am.
For treatment.
No, ma'am. The report we got was the least restrictive measures available was Florida State Hospital. And that's all I can do. That's what I'm
Other
bound to do.
place? Please
Ma'am?
don't send her there.
I can't,
I
there's
beg
nothing,
you.
no,
Please
ma'am.
don't send her there.
There's nothing.
They abuse her when she goes there.
Listen to me. When you get, and I don't know that they abuse her.
They
But
do.
let me just suggest something to you. When you get law enforcement involved in somebody who's mentally ill, my hands are handcuffed also. There's nothing, I can't send her anywhere else because I've got an opinion that the least restrictive measures is available is the Florida State Hospital.
How can that be the least restrictive when there's a hospital right here?
Ma'am, this is the doctor's opinion that they can't, that this place can, that out of custody can't do it, that it has to be at the hospital. I'm bound by that. And I'm just telling you, I'm bound by that.
They have
If you want to keep her out of the criminal justice system, do something private before she gets arrested, because when she gets arrested, she has felonies. That's the only way I can deal with it. And I'm sorry.
Are they gonna drop the charges because she was?
That's up to the state attorney's office. That's
I
not
need
up to me.
talk to them. I need to find out what.
You need to go talk to the state attorney's office and set it up, or the victim does, or the alleged victim, and needs to set an appointment
He
with
already
them.
has talked to them and he asked them to drop the charges and to send her to.
Well, that's up to them to do it. Well,
And
listen to me, when the charges are dropped, nobody can send her anywhere. I don't have any, when the charges are dropped, I have no jurisdiction over. It'd be up to you.
can't just charge her to go to like.
No, ma'am.
Inpatient.
No, ma'am. If the charges are dropped, no, ma'am. That'd be up to you to do it. I have no jurisdiction when the charges are dropped.
What's gonna happen to her when she gets out of
I
Chattanooga?
don't know, ma'am. I understand that that is one of the crises of our country. But the court is, all I deal with is criminal cases. I don't drill. You can get a guardianship.
For permission to use his car.
Ma'am, that's a defense. I'm just telling you, if you want to do a guardianship, you need to go talk to a private attorney and set some sort of guardianship up. I can't do
What
that.
will that give me? if
I
have
don't know, ma'am. That's why you need to go hire a lawyer and talk to them. I can't give you that advice. I'm a criminal judge. I have the criminal docket.
She is not a criminal. She is mentally ill.
I understand that, ma'am, but that is up to you. If there's nobody else to do it, you may be the only person who could do that, but you need to go talk to an attorney who deals with guardianships and probate.
Well,
to
if
do
I had
that.
known it was gonna turn out like this, I would have paid the $500 bond. I would have gotten her out. I would have put her in life management.
Well,
got
ma'am,
her
I
treated.
can't help that. That's past that.
It is.
It's
She
past
has
that.
sat in
But listen
jail.
to me. Listen to me. You're asking the criminal justice something to do that we're not equipped to do. There's something that you have to do, that you need to do on a private basis, go hire an attorney. There are attorneys who deal with this.
Can you tell me a good one?
No, ma'am, I can't give you any advice on that, but
I
there,
need an attorney.
but there are plenty of good ones, I
I'm
promise you.
there For her to sit in jail. for
There
months.
are attorneys that can handle that.
When's she going to Chattahoochee? Can
Whenever
you
they
tell
get
me
a bed
that?
available, I don't know.
Yeah. Well, can I get her out?
No, ma'am.
She's gonna have to wait to go to Chattanooga.
Yes, ma'am.
Nothing that can be done.
No, ma'am.
She committed a felony. Yes, she's mentally ill, but she committed a felony. From the sounds of it, grand theft auto. And I'm sorry, but if you knew she was mentally ill and if you knew she was, struggling with impulse control, let's call it that, perhaps you should have gotten the guardianship. Perhaps you should have taken preemptive measures to this happening. But now she's got a court case and they can't do anything more than what they can do.
No, ma'am. I didn't know.
This is sad.
Well, it is sad, but I didn't arrest her.
Very sad. She's deteriorating every
Well,
day. She
ma'am,
sits in
Let
jail.
me just suggest to you, you need to go talk to an attorney. An
I
attorney
thought
who,
I had one.
well, that's a criminal attorney. That's all she's bound to
I
do.
thought I had one here.
Where,
I thought I had a public defender.
ma'am, she's done everything she's supposed to do. That's what she's supposed to do. And she can't do anything else until I find that your daughter's competent. Now,
I knew she wasn't competent.
well, I understand that, but when she's arrested and charged with a
I
felony,
took
we're
her to the
bound.
jail. I took her to the jail.
Well,
and
before
I
she got,
said, "Turn yourself
let me just
in."
tell you something. Before she got arrested, you should have been hiring an attorney and done something that way. And I'm sorry to tell you that
I
that's
did
what,
not realize that the public defenders were going to do this to her.
they have not done a thing to her. And man, I'm gonna tell you something. They have not done a thing.
That's
They're done
right. They
exactly
haven't
what,
done anything
this,
for her.
ma'am, this hearing's over with. I'm just telling you, they've done exactly what they're supposed to do. Yes, sir. I'm sorry.
I love you guys. Be safe, be well, sleep sweet, and much love.